Hi guys, it's Kathy. I hope you're doing well. Alright, we do have a soft set, which is the only reason why I got the clip to begin with. The audio is not the greatest, but it's fine. I mean, it's okay. And I made it special so that if you can't hear a part, you'll be able to understand. You'll see. It's not terrible. We can hear him. He's just not, we just don't hear him the best.
Good morning, sir. Okay. We are.
Basically challenge subject matter jurisdiction, especially jurisdiction. And then also now it's validity dismissal on I want to say 01/12/26. There was an entry for dismissal.
Okay. So a couple of things. As the subject matter jurisdiction, this court has subject matter jurisdiction because the Superior Court has jurisdiction over crimes alleged to be committed in the state of Indiana based on the laws of the state of Indiana. So I find that we do have subject matter jurisdiction with respect to personal jurisdiction. This crime is alleged to have taken place in St. Joseph County, Indiana, and we're present here in the court. So the court does have personal jurisdiction over this case. With respect to the dismissal, there's no dismissal that has been entered, so I'm not sure to what you are referring.
That's what I was still have this gap.
Okay, well, I have meet CCS, so.
Yeah, you make a monthly with this time.
Okay, so it looks as though that entry is voided because it was entered in error. It says void last entry, so that's already been taken care of. So I don't know if there's anything else to address because that was already voided out as it entered in error. So there was no dismissal in this case. Okay, Mr. Cripe,
Yeah.
is there an anticipated resolution of this case today, or are we looking to get that on the trial now?
Straight plus two.
All right. Well, state, do you know if is there a resolution proposed in this case?
There is a plea, but Mr. Curley was not interested in the state's offer or looking at it. It's also just to make record clear. I'm the step of BPA to speak to Mr. Crickler, and he's refused to provide the permission to get the state's discovery. So.
Okay.
So you know that's getting time. I need to start so I can see everything's going into.
Okay. Well, here's what I'm going to do is I'm going to set the matter for trial. Mr. Crickler, I would suggest if you want to get the state's discovery, the information the state has that they're required to turn over with respect to the information about this case, any reports, photographs, any documents or exhibits that they intend to introduce. They're required.
I won't give you. She just said, have jurisdiction. I will need that document.
Well, it's on the record. I'm not going to write an order saying that I have jurisdiction when I've already issued and I've already said that I have jurisdiction.
So I can actually get that.
What do you mean?
I can actually get that information.
Yeah, what is it?
Which you stated, you have personal jurisdiction subject.
I don't know what you mean, so. I'm trying to understand this, but what do you, what is it that you're asking?
Said subject matter jurisdiction.
Right, which I already indicated that this court was at. All right, I just want to set on the trial calendar.
The reason why I asked that because I want to see any contracts setting place. If you could pull that out.
Okay, this is all based on contracts.
So what? On for instance.
Okay.
Also,
I'm sorry.
but the one report is this.
It's Superior Court exercising criminal jurisdiction.
Criminal jurisdiction.
Correct.
Other than intervening by the nature.
Okay, Mr. Krieger, I'm gonna tell you this. I know exactly what you're saying, because I've heard this a million times.
I'm sure you have
And nobody who has presented that has had to succeed.
means. I'm just explaining.
No, I'm not here to argue either. So you're asking about whether there's a contract or an injured party. Those are based on common law jurisdictions. Well, it's not common law, it's based on statutory jurisdiction.
No, they,
No,
Well, then let's not argue, let's just set the matter for trial.
that's not what I said or meant.
Let's look at.
I am happy that other people are showing all the judges, not just Michigan and Washington anymore. So I'm pleased. It's wonderful news. It's great news. And it's Judge Eric. And he's so good. So good.
I'm sorry, when you refer to that, are you referring to like the US Constitution? Because this is not a federal court, this is state.
Yes.
Okay.
I will right.
Probably better than you would.
Fines and penalties.
All right, let's come back to trial. Let's look at that on. Ms. Harmon, this is a EO5 whose case we will see initiation of the.
It would be a Friday trial.
Friday trial. Trial date will be March 27th, 3/27/26. I'll give you a reminder of all these dates are pretty. I'm sorry.
The 7th, we go to the report.
Okay, so with the trigger, let's talk, not quite done yet, I want to give you another date as well, because we set all trials for 2 different dates. So the first trial date will be, the trial date will be March 27th at 9 a.m. For that, we will have a final hearing on March 17th. We call record 3/17/26 at 9 a.m. in this courtroom. At that date, we will confirm that all parties are ready to go to trial. If everyone says yes, they are ready to go to trial, then we will come back on March 27th at 9 a.m. for a bench trial in this matter. If you want to have a jury trial, you need to make a request in writing at least 10 days before March 27th, or you lose the right to a jury trial. If you want a jury trial, it will be set for a different date.
I'm not here to keep you rights.
Nobody's asking you to waive any rights.
Saying that. Maybe.
Not waiving any. I didn't say any rights. Well, that is a procedural matter. If you do not make a request in a timely fashion, then you lose the right. That's not a waiver. That is your election. So if you don't do something, you lose. I'm not doing it. So March 17th, 9 a.m., March 27th, March 17th is the record date, March 27th is the trial date.
So for that, on the record, David, that you mess up that when a jurisdiction person, they can chew
I don't know how much more clarification.
All right.
Nobody who has ever tried that defense has succeeded, he said. Yeah, we know. We know. Let's go to Colorado.
Your Honor, we have Mr. Tyler Davis on Station 2.
Good morning. Please state your name for the record.
This judge is pleasant. He is a pleasant judge.
And Deputy Station 2 is currently muted.
Hi, good morning, Your Honor. My name is Tyler Davis.
Morning, Mr. Davis. Magistrate McDonald, this is case number 26, CR 136. And while you're waiting, do you have a chance to review the advisement information that was provided to you?
I have nothing in my hands. There was nothing provided to me at all.
Mr. Goldstein, have you had a chance to visit with our defendant here?
I have.
Can you waive further advisement at this time?
I do.
Thank you. And Ms. Walk, the people's position on bond.
Thank you. In this case, the people would be requesting a $5,000 cash bond. Oh, Sorry, my computer
Oh,
just
we're not
froze.
gonna have all the other conversation.
$5,000 cash bond or the commensurate cash surety bond. The people do have community safety concerns as this charge does involve a firearm and a
Yep.
stolen firearm. And so we would be asking for standard pretrial supervision, monitored sobriety, and we would adopt the remaining recommendations, including that he be ordered to not possess any weapons, firearms, or ammunition while on pretrial.
And Mr. Goldstein?
I hardly see how a $5,000 cash only bond would be justified.
I mean, neither.
When he gets out, he'll go stay with his girlfriend. He has cell phones so that he can check in with pretrial services.
Plenty of them.
He says that he'll follow all of the requirements. He thinks he could post about $40.
No,
I'm
no.
asking-
When he said plenty of them, did he mean girlfriends or cell phones? Do you know what he meant?
Say that.
Hey, here's the thing, Mr. Davis. We're in a virtual courtroom.
Yep.
One person can only talk at a time if there's to be any semblance of a communication, and you're talking over people. So I'm really asking you nicely to not do so, because it's hard for the record to be kept, and it's hard for me to understand anything that's being said. So I would beg your indulgence and ask you to be quiet, please.
My apologies, Your Honor.
And Mr. Goldstein, you were saying?
He's asking for a PR bond, but if the court's unwilling to do that, I'm asking for a $40 cash bond.
I could pay 100. 100 or more, 500, whichever. Doesn't matter. I just want to continue my day.
Well, what I'm going to do is I'm going to set bond at $500 cash only.
Perfect.
MIPS is authorized. MIPS is mental health counseling and or services. It's there for your benefit. You don't need to participate if you don't wish to.
I want to participate in anything that'll help me continue my proposal.
Standard supervision.
Judge, do you have something stronger than MIPS? Maybe?
You must remain law-abiding at all times. Report to pretrial services within 24 hours of your release.
Write that down. Write that down.
Because you're alleged to have violated a Title 18 charge, you're subject to a mandatory protection order pursuant to CRS 18-1-1001, which will remain in place until final disposition of your case. Pursuant to that protection order, you should not harass, molest, intimidate, retaliate against, tamper with any witness to, or victim of the acts charged. Violation of the protection order may result in you being held in contempt or otherwise in the filing of new charges against you for violation of a protection order. I'm going to order no weapons. Your next hearing date is, well, I'm going to take a step back. Ms. Walker, what's the people's position as to a no contact with?
Monica's on a 60 stream streak on Twitch, guys. 60 in a row. If you miss one stream, you lose. You lose those streaks. And let me just tell you, Twitch streaks are so buggy that you lose these streaks for no reason sometimes. Sometimes they go well. She's made it for a 60 right now.
The alleged victim or victims?
Your Honor, we would be asking for that no contact order.
Mr. Goldstein, the defendant's position?
I think it should be a standard Title 18 protection order.
And it's probably more than that. Because I started a stream, I don't know, 60 days ago by accident. So nobody knew about it. And I think that blew away her streak. Kelly's too.
I am going to go with the no contact with the 25-yard distance restriction as to Lee Davey, date of birth 7/2/64. Your next hearing date is February 17, 2026, 8:30 a.m. in courtroom 5C. Is there anything further, Ms. Walker?
No, thank you.
Is there anything further, Mr. Goldstein?
No, there's not. Thank you.
All right, Mr. Davis, best of luck. Have a good day.
Thank you so much. I appreciate everybody. Go listen to Rose.
I love whoever muted him. I love them.
Your Honor, I have Mr. Anthony on station 3.
Good morning. And there we go. Good morning.
Good morning.
Please state your name for the record.
Jesse Allen Anthony.
Right, Mr. Anthony, I am Magistrate McDonald. This is case number 26M5035. This is a VRA case. Is the alleged victim with us in the virtual courtroom? So hearing no one, we will continue. While you were waiting, Mr. Anthony, did you have a chance to review the advisement information that was provided to you?
Yes, I have.
Do you have any questions as to your rights at this time?
No.
Right. And Ms. Walker, the people's position on bond.
Thank you, Your Honor. The people would request a $500 cash only bond. We do have serious concerns about the elevated DVSI score of 11, as well as a higher CPAT score of 2. This defendant also has 2 prior DV convictions, so we would adopt the remaining recommendations, but ask that the court issue the requirement for firearms relinquishment under 18-19-1001, subsection 9, and that he be ordered not to possess any ammo or weapons or firearms. We would also ask for that no contact order to be issued for Helen Garcia, the named victim in this case.
And Mr. Goldstein.
Well, it's a DV case, so the prohibition on firearms is mandatory. I also didn't see in the pretrial services report that he has access to or ownership of firearms, but that's certainly something you can ask him. He does have his own place to go. He is asking the court to allow him to have a civil standby, understanding that there's a mandatory no contact protection order that will issue. He has a cell phone so he can check in with pretrial services. He also has reliable transportation so he can make his court dates. He has been in Colorado for his entire life and currently has a job working as a cook at the Penelope's restaurant in Estes Park. I'd also note that he has no failures to appear. The recommendation is for 1250 co-PR, which I think is appropriate, but he told me he'd rather have a cash bond, so I'm asking for a bond between $150 and $200 cash. Thank you.
Give me a moment, please. Okay, so what I will do is I'm going to order a bond at $300 cash only. Monitor sobriety is directed by pretrial services at the standard level. No alcohol, no illegal drugs, no recreational marijuana. Random BEAs, random UAs with ETG authorized. NIPS is authorized. NIPS is mental health counseling and or services. It's there for your benefit. You don't need to participate if you don't wish to. You're to report to pretrial services within 24 hours of your release. Because you're alleged to have violated a Title 18 charge, you're subject to a mandatory protection order pursuant to CRS 18-1001, which will remain in place until final disposition of your case. Pursuant to that protection order, you should not harass, molest, intimidate, retaliate against, tamper with any witness to, or victim of the acts charged. Violation of protection order may result in you being held in contempt or otherwise in the filing of new charges against you for violation of a protection order. I'm going to order no contact, no exceptions, with a 25-yard distance restriction between the defendant and the alleged victim, Helen Garcia, date of birth 11/7/69. Because you're alleged to have violated a because you're alleged to have committed an act of domestic violence, you are subject to a mandatory firearm and ammunition relinquishment. You must relinquish any firearms and any ammunition in your possession within 24 hours of your release, and you must fill out the relinquishment packet of information and return that to the court within 7 days. Failure to relinquish your firearms and ammunition and or the failure to return the packet of information and signed to the court within that 7-day window may result in your being held in contempt, may result in new charges being filed against you, and or may result in your bond being revoked. Your next hearing date is February 11, 2026, 1:45 p.m., Courtroom 3D. Is there anything further, Ms. Walker?
No, thank you.
Is there anything further, Mr. Goldstein?
No, thank you.
All right, best of luck. Have a good day.
Your Honor, we have Jesse Salazar on Station 1.
Good morning.
Good morning.
Please state your name for the record.
My name is Jesse Alfred Salazar.
Morning, Mr. Salazar. I'm Magistrate McDonald. This is case number 26M5043. While you're waiting, do you have a chance to review the advisement information?
Yes, sir, I did.
Do you have any questions as to your rights at this time, Mr. Salazar?
No, sir, I don't.
All right, just give me a moment, please, so I can pull up your case information.
Excuse me.
No worries. And Ms. Walker, the people's position on bond.
Thank you, Your Honor. We do have input from the named victim, Elaine Seaman, on this case. She is in favor of a mandatory protection order, a no contact order, GPS monitoring, MIPS being authorized. She is asking for a high cash bond, and she is okay with a civil standby in order to allow him to get his belongings. As for the people's position, we are requesting a $750 cash only bond. This defendant does have an extremely high number of failures to appear, as well as 2 active warrants already in Larimer County, with his most recent failure to appear occurring just this month on the last month, January 14th of 2026. And so in addition to that, the 2 counts here do show a lack of compliance with court orders. So we are requesting that higher cash bond. We are in agreement with the remaining recommendations.
Mr. Goldstein.
I'm asking the court to follow the recommendation of pretrial services and set a $125 cash bond. He wants the court to know that his mom is manipulating him and using the protection orders to control him. She basically invites him over and then gets upset when he won't give her money and puts the stress onto him by calling the police on the protection orders. And he wanted you to know that. So I'm asking you to follow the recommendation of pretrial services.
Okay, thank you. I will set bond at $300 cash only. And I'm going to order standard supervision. You must remain law-abiding at all times. MIPS is authorized. MIPS is mental health counseling and/or services. It's there for your benefit. You can participate if you wish. You're not required to do so. You must report to pretrial services within 24 hours of your release. And because you're alleged to have violated a Title 18 charge, you're subject to a mandatory protection order pursuant to CRS 18-1-1001, which will remain in place until final disposition of your case. Pursuant to that protection order, you should not harass, molest, intimidate, retaliate against, tamper with any witness to or victim of the acts charged. This violation of the protection order may result in you being held in contempt or otherwise in the filing of new charges against you for violation of a protection order. Given that there were already 2 cases in which the alleged victim is a named no contact in their protection orders, I don't deem it needs to be done here. At some level, these follow-up cases become the tail wagging the dog. And ultimately, if the court wishes to modify the protection order in the parent cases, the court may do so, but I'm not going to order that here. Your next hearing date, Mr. Salazar, is February 24, 2026 at 1:30 p.m. in courtroom L1. Is there anything further, Ms. Walker?
No, thank you.
Is there anything further, Mr. Goldstein?
No.
All right, Mr. Salazar, best of luck. Have a good day.
When did they change the wrenches to a shield? You guys are warriors. You have your shields now.
Thank you.
Your Honor, I have Mr. Cripe on Station 2.
Good morning.
Good morning.
Please state your name for the record.
Levi Cripe.
Mr. Cripe, I am Magistrate McDonald. This is case number 26M102. While you're waiting, do you have a chance to review the advisement information that was provided to you?
Yes, sir.
Any questions as to your rights at this time?
No, sir.
All right, and Ms. Walker, the people's position on bond.
Thank you, Your Honor. If we could, I do believe I saw the named victim online. If we could check if they had input.
Fair enough. This is a VRA case. Is the alleged victim, Shauna Cripe, with us in the virtual courtroom?
Yes, I'm hoping you can hear me.
Yes, I can.
Okay,
Just
perfect.
you want to tell me in the context of bond and or the protection order?
I'm sorry, say one more time.
Is there something you wish to address to the court in the context of bond or the protection order?
For Levi Cripe?
Yeah.
Yes, for in regards to myself, Shauna, and for Ava Cripe. Am I saying this correctly? I'm sorry. I'm just.
What do you want to tell me?
Oh, well, I don't know if you're able, my recommendations, or should I let you guys proceed with your things?
So this is what's called a VRA case. It's a victim's rights amendment.
Okay.
And what that means is that you have the right to input during critical stages.
Yes.
And so contextually, the way the courts perceive the initial bond is that it's not a critical stage, which I kind of think is the height of lunacy.
And he's right. He's right. When they set the bond, it's not critical, so the victim doesn't really have to be there for that. What?
It doesn't really matter because no one cares what I think. Point simply being that if you wish to have the opportunity to advise the court in the context of how it should set bond and or what it should include within the protection order, this is your opportunity to do so.
Yes.
So is there something you want to tell me in relation to the protection order and or bond?
Yes, sir. I'm sorry. I'm trying.
Don't be. Relax. It's all good. So, what do you want me to know?
Okay, I've thought about this a little bit, so I would like for there to be no contact until he is successfully in a program where he can get help, with the exception of talking parents at, but not until he's in a program. As for bond, and the bond is up to you, of course, but that's why I would like to say no contact until he's placed into a program.
Right. Anything else?
I don't think so at this time.
Super duper. Thank you.
Super duper. Tina, super duper. You're on a 55 streak on Twitch. Thank you so much.
Thank you.
And you were saying, Ms. Walker.
Thank you, Your Honor. The people would be requesting a $750 cash-only bond on this case. This defendant does have a history of violence with the same named victim, and he also has an extensive history of failures to appear. He also refused to cooperate when officers came to his door to speak with him about this incident, and so we do feel that a cash-only bond is appropriate here. He's also again charged with that violation of protection order, which shows a lack of compliance with court orders that have already been issued. We would also ask for monitored sobriety to be a term of his pretrial supervision based on the fact that the underlying facts allege that he was trying to get to a liquor store. And I do believe that that is, based on what the named victim just told the court, I do believe that is appropriate in this case. So we would be asking for that mandatory protection order and no contact order for both Shauna as well as their daughter, Eva, and then that he be required to relinquish all firearms.
All right, Mr. Goldstein.
Thank you. When he's released, he actually is planning to go into a treatment program. He has a bed there waiting for him. That's the 180 Ministries Teen Challenge, which is a Christian men's recovery program. He's a union millwright, so if he can get sober, he does have work by the plenty. He has a driver's license currently, but he doesn't have a car, but he thinks he does have reliable transportation. He has a cell phone so he can check in with pretrial services. He has 5 children, but only one that's under the age of 18 that he's still supporting. He can't afford to post any bond. He's asking for a PR bond. He's okay having no contact for now, but he really just wants to get back into that recovery program, which again is 180 Ministries Team Challenge. That's all.
Mr. Goldstein, when's that bed available?
He told me that it's available immediately.
Chocolate. I love chocolate.
All right. Chihuahua. All right. So what I'll do is the following. I'm going to issue a kind of an interesting bond in that we'll see what happens. It's $750 PR. However, there's a contingency here, and that contingency is that you must report and be accepted to 180 Ministries Team Challenge rehabilitation, inpatient therapy within 25 hours of this order. So no later than 11:30 a.m. on February 2 of 2026.
Monica, can I drink chocolate behind your back? Would you be upset if you heard I was drinking chocolate behind your back? See, Bobby, Monica would definitely not be upset about that. She would be like, oh my God, you were drinking chocolate? Oh, that's so cool.
Have not reported to 180 Ministries Team Challenge by 11:30 a.m. on February 2 of 2026. You are ordered to appear before the court in courtroom 1A to have your bond modified accordingly. Having said that, monitor sobriety as directed by pretrial services at the standard level. No alcohol, no illegal drugs, no recreational marijuana. MIPS is authorized. MIPS is mental health counseling and or services. It's there for your benefit. You don't need to participate if you don't wish to. Random BAs, random UAs with ETG authorized. You must remain law-abiding at all times. Because you're alleged to have violated the Title 18 charge, you're subject to a mandatory protection order pursuant to CRS 18-1-1001, which will remain in place until final disposition of your case. Pursuant to that protection order, you should not harass, molest, intimidate, retaliate against, tamper with any witness to, or victim of the acts charged. Violation of the protection order may result in you being held in contempt or otherwise in the filing of new charges against you for violation of a protection order. I will order a no contact between the defendant and the alleged victim, Shauna Cripe, date of birth 9/19 of 78, with a 25-yard distance restriction. The exception to that will be communication in relation to the minor child and or home finances. Talking Parrot is a email communications platform that has all of the communications preserved so that the courts can review it if needs be at a later date. I'm not ordering a no contact as to the minor child EC. Let's see. Because you're alleged to have committed an act of domestic violence, you're subject to a firearm and ammunition relinquishment. You must relinquish any firearms or ammunition and or ammunition in your possession within 24 hours of your release. You must also fill out a relinquishment packet of information and return that to the court within 7 days. Failure to relinquish firearms and ammunition within 24 hours and or failure to return the relinquishment packet within 7 days may result in you being held in contempt, may result in new charges being filed against you, and or may result in your bond being revoked. You are to report to pretrial services within 24 hours of your release. Your next hearing date, Mr. Cripe, is February 12, 2026, 1:30 p.m. in courtroom L2. Is there anything further, Ms. Walker?
No, thank you.
Is there anything further, Mr. Goldstein?
No.
Best of luck, Mr. Cripe. Ms. Cripe, thank you so much for joining us today.
Thank you,
Have a
sir.
good day.
Have a great day.
Is there any way I could say something real quick, Your Honor, please?
You can, but it needs to be directed to me.
Yes, sir.
And this is one where your attorney would be leaning over very close to you and saying, "What do you want to say?" Recorded.
It is
So-
very important. I have court in Loveland at 10 a.m. tomorrow, and I'm fully intended to go. I need to get my stuff rounded up. And so I don't know, maybe you could give me a couple more hours to get to Denver. The bed is already there for me. I was there when they presented these charges to me, and they asked me to leave and go take care of these and come back. I just need a little bit of time to get there after court.
All right, Mr.
Couple
Cripe,
hours.
that is very important, and I appreciate that. The goal here is not to have you competing in the greatest race. The goal is simply to have you in a place where you can get help.
I promise.
And so I will simply say that you're either at the 180 Ministries Team Challenge at 1:30, or you are appearing in Courtroom 1A at 1:30 via WebEx. You would need to contact the court to get that information. But that gives you another 2 hours. Is that going to be enough time for you?
I appreciate it. Yeah, it's going to have to be.
Well, Mr. Cripe, like I said, this isn't the greatest race. This is, I'm making an extraordinary order here by giving you an either or. I don't do that very often, like ever.
I appreciate you.
So the goal here is for you to get the help that you've identified you want.
Yep.
I'm just trying to do it in a very, very strict paradigm to ensure compliance. All right?
Understood.
All right.
Thank
Best
you.
of luck. Have a good day.
You too. Thanks.
The lawyer's the star of this
Your Honor, I
show.
have Nathan Owens on Station 3.
Good morning.
Good morning, sir.
Please state your name for the record.
Nathan Paul Owens.
Mr. Owens, I'm Magistrate McDonald. This is case number 26M5032. And while you're waiting, do you have a chance to review the advisement information that was provided to you? Do
Yes, Your Honor.
you have any questions as to your rights at this time?
No.
Right. And Ms. Walker.
Thank you. The people would be requesting a $2,500 PR bond on this case. Beyond that, we would adopt the remaining recommendations.
Right. And Mr. Goldstein.
I mean, I think it's kind of shocking that an arrest was made here. I'd say, again, I understand that you've already found PC, but I'm just not seeing it based on what's in the affidavit. I'd also note that it appears that the parties all were under the belief that the protection order was modified in a Weld County DR case, or at least at the Boulder case that originally had the protection order was modified through the Weld County DR case to allow them to have full contact. And I looked at that DR case, but I couldn't find any protection order. It looks to me like there was originally, a request for a permanent protection order, but
Okay. He's talking about a Weld County case. He's talking about a Boulder County case. This is Laramie or whatever county. So there's 3 cases. There's at minimum 3 cases in 3 different counties. Probably more cases, but at least 3 counties. So yeah, I don't know why you're surprised that he messed up.
that was withdrawn. So I basically don't believe a crime was committed here. I'm asking the court to follow the recommendations of pretrial services, and hopefully they can get this sorted out. That shouldn't be too difficult. But I mean, this is wild. That's all.
Well, I appreciate your input there, Mr. Goldstein. In the context of PC, it is what it is. But in the context of how the court is approaching it, I think that you will be able to perceive where I stand on some of these issues. Having said that, I'm going to order a PR bond at the $100 level. Allegations that you were notified of an accident in which your wife or ex-wife, whoever the protected party was involved, and you showed up, shows that you're human, not necessarily that you're criminal. However, it is technically a violation of the protection order, and thus there is PC, and that's why I'm going to go with the $100 PR bond. Nonetheless, there is a mandatory protection order pursuant to CRS 18-1001 that will be that remains in place until final disposition of your case. Pursuant to that protection order, you should not harass, molest, intimidate, retaliate against, tamper with any witness to or victims of the acts charged. Violation of the protection order may result in you being held in contempt or otherwise in the filing of new charges against you for a violation of a protection order. Must remain law-abiding at all times. I am not going to order a no contact in the protection order. And your next hearing date, Mr. Owens, is February 9 to 26 at 1:30 p.m. in courtroom 5D. Is there anything further, Ms. Walker?
No, thank you.
Is there anything further, Mr. Goldstein?
No, thank you.
I liked that judge. I enjoyed watching that judge. Super duper. All right, guys. I want to play Judge Fish next, but I am getting some weird computer signals when it comes to this video. So, I don't know. Oh.
20.
It's not loud enough.
2512 F613445 and 64 D01 2512 F513840. Defendant appears in custody pro se. State is represented by Deputy Prosecutor Hammer. We were reset from yesterday, Your Honor.
Thank you, Mr. Deputy Prosecutor. Good morning, Mr. Conger.
Good morning.
How are you today?
I'm all right, I guess.
Sir, you filed a motion to fire your attorney. I let him out of the case yesterday.
Yeah.
And you asked me to determine whether you can proceed on your own and without counsel. I sent a couple documents out. Well, it's one document, a couple pages worth out to the jail yesterday. Did you get that?
Yeah, but I don't know if that's saying I gotta waiver all my rights. I'm not trying to waiver my rights if I'm going to trial. You don't have to waiver your rights if you're going to trial. I still want all my rights. I still want to cross-examine my witnesses and all that. I feel like this ain't my job really, but I'm pushed to the point where I have no other choice. And yeah, that's about it.
Okay, nobody's asking you to waive any rights, sir. That's not what the paperwork is about. It's a Faretta.
So
it's called Faretta. All right.
I have to fill that out then, or what?
Well, we'll go through it together here in a minute. Yeah. What's important? Yesterday, I couldn't work with you because you kept interrupting me.
Yeah.
And you weren't answering the questions that I was asking, and I didn't have time really to slow it down because we had 40 some odd cases we had to cover yesterday.
I don't know if I trust filling that paperwork out, to be honest with you, because you're telling me I got a level 5 when they were level 6s. You brought, and then when I came to jail, you brought an extra charge. You brought an extra charge when it was only an invasion of privacy. You brought it back. You gave me another charge of intimidation when it was only invasion of privacy in the first place. So I really don't trust filling that paperwork out.
Yeah, Mr. Conger, I didn't bring any charges against you. Just so you're aware, I'm the judge. The state brings the charges against you.
Yeah.
This guy over here and the prosecutor. I don't do any of that. That's the people bringing those charges against you, not me. You understand that?
Yeah, well, just clear it up again. It was only invasion of privacy. And then it turned into intimidation. And then yesterday when I went to court, they were level 6s. And then they turned to level 5. So,
No, sir, just so you're aware, you have two cases pending before the court. One of them is under short cause F613445. It's a level 6 felony. It includes 2 counts. In those 2 counts, one of them is invasion of privacy, a level 6 felony. The other one is a intimidation, a threat related to a prior lawful act, a class A misdemeanor. You aware of what you're charged with, sir?
yeah, the invasion of privacy was a misdemeanor. You're saying that's level 6 too now, or what?
I'm telling you, there are 2 cases, or 2 charges rather, in F613445 that the state has brought against you. I'll go through them with you specifically.
The intimidate when you brought the intimidation up after I already told I only had an invasion of privacy. When you brought the intimidation up, that was the level 6 felony, and the invasion of privacy was a misdemeanor. But you originally only told me I had an invasion of privacy, and that was just a misdemeanor.
Sir, back on December the 8th, 2025, state of Indiana filed the case, which is cause number 64D03-2512F6-13445. Originally, it was in Judge Drenth's court up in Portage. And you were involved in an initial hearing at Judge Drenth's court, held by Judge Drenth, where he should have gone through an advisement with you related to the charges in this case. His order says he did, but I want to make sure that I do it again, just to make sure you understand what you're charged with in short cause F613445, okay?
Man.
So count 1 alleges invasion of privacy, a level 6 felony, and it says that you violated a no contact order contrary to statute, and you had a prior unrelated conviction for an offense under that same subsection. So because of the prior offense, it gets elevated from a misdemeanor up to a felony.
Yeah, well, he should.
You understand that?
Not really, because they told.
Which part don't you understand, Mr. Conger? The words I used are what they mean.
They told me it was a misdemeanor when I got to jail. How can you bump it up after you told me it was a misdemeanor?
My assumption would be that whoever worked with the officer on these charges learned about the additional conviction, past conviction, and made sure the officer understood he had to enhance the charge up to a level 6 felony based on Indiana statute.
I don't think you should be able to do that, in my opinion. You should just told me it was a level 6 felony in the first place. You can't just keep changing your mind, bringing up extra charges. You should have just brought all these charges in the first place. You can't change your mind after a week and give me another charge or nothing like that. That's wrong.
Mr. Conger, you could actually change your mind up to some months following the, actually you could change your mind on the charges up until the statute of limitation expires on the charges. Understand that? So if there's a 2-year statute of limitation, they could have charged that on the 700th day if they wanted to. Bumped it up to a felony, whether you like it or not. The Supreme Court of the land, United States Supreme Court says that's okay.
I don't agree with that, and that don't make sense to me, but.
Okay, well, I mean, I want to have a conversation with you about a case called Faretta, which is about your ability to represent yourself in court, pro se. And if you can't understand that and grasp simple things like statute of limitations and the state's ability to bring charges against you based upon statutes, then I'm really concerned about your ability to represent yourself. Well, I want to get into this more because I want to make sure you have a full advisement of your rights under F6. What am I into? 13445. Okay. So count 2 alleges intimidation, a class A misdemeanor. And this one says that you threatened a Virginia Conger such that she'd be placed in fear of retaliation for a prior lawful act. And I think specifically they allege that you threatened to kill her. Yeah. Yeah. Threatened to kill her when you were released from jail because she wasn't going to let you back into her house. That's what they allege. You understand what they allege, sir?
No, I don't understand because that didn't happen.
Which part do you not? Well, then
I don't
again,
think-
so
I
now
don't
you're
think
getting
we're
Mr. Conger.
I don't
Mr.
think we're
Conger,
officially
you don't
in
talk
trial
over me,
yet.
sir. You don't talk over me. Whenever I'm talking, you're not talking. All right, I'll do my best to respect you, but you need to understand that if you don't understand the charges, what part of it do you not understand? The words that I'm using or what they mean? Because what you said was you didn't do that. But what you're not here to do is to argue your defenses because there's nobody here to listen to that. There's no jury here. The state, the more you tell them,
Yo, I'm listening. Judge, shut up.
the more they're going to use it against you. You understand that? So all I'm trying to figure out is if you understand whether what they allege you did, right? And what they're saying you did is threaten your mom. You're going to kill her because she wouldn't let you back into her house. That's what they say you did.
I understand what the charge means. but
That's
no-
fine then. We need to move on to the next step.
I didn't do it, no. And
I already entered a plea of not guilty for you too, Mr. Conger. If Drenth didn't do it, I'm going to do it. Enter preliminary pleas and not guilty for you, right?
Yeah.
That's statutory. We're
great.
required to do that because you know this is America, sir. As you sit here today, you're innocent. You understand that?
Yeah, I'm innocent. Yeah.
I understand that. As you sit here
We
today,
ain't officially in trial yet. I don't think so. I ain't gonna get in.
you've got pleas of not guilty on the record for you,
Yeah.
right? Because
Yeah.
as you sit here today, you're innocent
Yeah.
in the eyes of the law. You get that?
Right.
That's
So are you,
constitutionally
Bobby.
protected.
Innocent.
That's what America's all about.
Yeah.
You get that?
Yeah, I agree.
All right, sir. Class A misdemeanor, you know what the penalty is for that?
Class A misdemeanor,
Yeah.
0 to 6 months.
No, we'll go up to a year on a Class A misdemeanor and up to a $5,000 fine. You understand that possible penalty?
Year to a misdemeanor? That don't sound right to me.
Class A misdemeanor is up
Oh
to a year
yeah,
in
you
jail.
might be right. You might be right.
I'm pretty confident, sir.
Yeah, you might be right.
Yeah,
I
I'm
think
pretty
he's
sure. I'm
right.
pretty sure of that one. And did you know what the penalty is for a level 6 felony?
Level 6 felony, 0 to 2 years.
6 months to 2.5 years, and up to a $10,000 fine.
What's 2 years? I thought.
No, 6 months to 2.5. You believe me?
Sounds like it could be right.
Okay, it's in the statute, sir. I could pull the statute up for you if you need me to.
Yeah.
Okay, so you understand what you're charged with in F6 13445, correct?
Yeah.
I can just imagine his son leaving a sock on the floor. And him having this conversation. You understand that that's a misdemeanor in this house. Do you understand what I'm saying, son? Yeah, well, Dad, it's just, no, do you understand what I'm saying, son? Dad, I just dropped it by accident. I understand that. You're innocent right now. I don't know how that sock got there.
All right,
I
good.
understand what it means, but I don't understand why I got charged with it, and I'm not admitting to it.
Nobody asked you to admit to anything, sir. What you've asked me to do is figure out whether you're able to represent yourself at trial. That's why we're here this morning.
Yeah,
And I have some advisement I have
I'm
to give you
confident.
first.
Yeah, I have no other choice. It really ain't my job, but I'm confident.
Okay.
It's the appropriate time to do that. Push me to my limits. There's stuff that just sounds credible, logical, believable, and then there's also stuff that sounds like you're smoking dope to me.
So I personally reviewed the charges in F513840. Looks like there was an initial hearing held.
I think this was
presided
the
over
third,
that.
Bobby.
You were in custody
4 days
back
ago?
on December 23rd. I presided over that. So I know I went through this one with you, but I'm going to do it again because I want to make sure you understand what they charged you with in F513840. Okay? So this one here says that you resisted law enforcement, that on or about December 12th, 2025, Porter County, out at the jail, you did knowingly or intentionally forcibly resist, obstruct, or interfere with law enforcement officers while they were lawfully engaged in the execution of their duties. And while you committed that offense, you inflicted a moderate bodily injury or otherwise caused moderate bodily injury to another person. Okay? And that's a level 5 felony. You understand that? You know what they say you did, sir?
It was a level 6.
Well, it's a level 5, sir. And you know why it's a level 5?
Yeah, well,
Because of the moderate bodily injury. They know, you know what they say you did?
I understand, yeah.
You do? You understand that they say you were fighting with them to get back into your cell, something related to your commissary, and that you took a fighting stance, tried to swing on one of the officers? You remember any of the facts here?
I'm not admitting none of that.
Nobody's asking you to admit anything.
We ain't
Just saying this
officially
is
in
what they
trial
think you
yet.
did.
I
They
understand
also-
what it means, yeah.
They also say then that as a result of that, and this is where you went from level 6 up to level 5, because it's the moderate bodily injury, is that you broke they say you broke somebody's leg. As a result, there's a dude who broke his leg.
I understand what the charge means, but I ain't getting into that. We ain't officially.
Oh, I understand.
We ain't
I'm with you.
officially in trial.
I'm with you. But that's why it's a level 5 felony. You know what the penalty for a level 5 felony is?
This conversation is monitored and recorded, right?
It's not only monitored and recorded, it's being broadcast over the World Wide Web.
Yeah.
Anybody in the world could be watching us right now.
Hi.
Well, good. Well,
Did they say if it was a guard or another inmate that got their leg broke?
It's exciting, isn't it?
yeah.
Modern technology and all that.
Mhm.
You know what the penalty is for level 5 felony?
No. No, I don't.
No guess on that one from you?
Mm.
1 to 6 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yeah.
And I already entered a preliminary plea not guilty for you on that one as well. And I set your bond at $5,000. You understand that?
Yeah.
Okay. So you requested a fast and speedy trial. You also requested that, I fire your attorney, or you fired your attorney. I let Mr. Patton out of the case yesterday, and I tried to go through the pro se representation stuff with you. I sent this stuff out to the jail for you to be able to review, and you thought that I was trying to get you to waive some rights, but I'm not doing that. Please raise your right hand to be sworn. You swear affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes,
Okay.
Your Honor.
Okay, so I haven't set a trial yet. I'm going to do that as soon as we get through this pro se advisement of rights. And I want to just make sure you understand where we're coming from. I've gone through the charges with you, correct? Are you currently under the influence of any alcohol or drugs?
Nope.
And are you on any medication at all that might affect your ability to understand today's proceedings?
Nope. No medication.
Have you ever
Wait.
been involved in any mental health?
I thought he just got back from military service. He was just deployed, and he just got back. He's going again? Because he did just
Any
get
doctor?
back.
Have you ever worked on your mental health with any doctor?
No.
Okay, so you don't have any sort of disability in that regard,
No, I don't.
and you're able to understand everything that's going on today.
I've held jobs and I worked and I've done a lot of good stuff in my life.
Fantastic. Okay. So you have the right to represent yourself in trial, just like you have the right to counsel and to have court-appointed counsel when you can't afford a lawyer. You understand that?
Yes, sir. Yep.
But before I can make that decision about whether you're allowed to represent yourself, I need to make some determinations about your ability to do that. Okay?
Yeah. Yes, sir.
Okay. So you know you have any number of defenses which might apply to your case.
A number of defenses.
You ever heard of defenses before?
Oh yeah, that's opposite of offense.
Absolutely. So-
Yeah, I have a lot of defenses. Yeah, but I'm not gonna get into it.
So you're the defendant, you have defenses, right?
Yes, I do.
Okay, absolutely. And you
All
know
right.
that attorneys are trained to know all those.
Yeah.
They study law for 3 years and they're trained to know all that. And then they practice law for some odd years before they get involved in your case. Patton's probably practiced law for 25 years. I don't even know, but I bet he's up over 25.
Well, I'm put in a situation where I can't really trust that, so I'm just gonna go with myself instead.
I'm not asking you that. I'm asking you just to acknowledge that lawyers get all that training and you don't have it. Do you acknowledge that?
Yeah, I acknowledge that.
Okay. Okay. All right. And I told you already what you'd be facing as far as penalties are concerned. You've got one case up to a year in jail and a $5,000 fine. One case that's 6 months to 2.5 years and up to a $10,000 fine. And one case that's 1 to 6 years and up to a $10,000 fine, right? So by my math, max penalty, public math is always dangerous, but 9.5 years, I think, is what that comes out to max. Is that right?
Yeah.
If we're
Oh,
doing the
well.
math right? Okay.
Oh well.
And do you know that there are factors I can consider
Yeah.
about whether your sentence should be what we call mitigated, which means made less than, or aggravated, which means made more than, towards the limit. Did you know that?
Yeah.
Okay, lawyers know that too, right? And they know how they can posture your case in the best way forward to be able to make sure all those are protected. Do you understand that?
Yeah. Oh well, whatever happens, if there is a Jesus or whatever, he could make up his mind whether you're a piece of shit or not. I guess. That's all I could say about that.
Yeah, well, Jesus doesn't have a whole lot to do with this. You understand that?
Mhm.
You understand Jesus isn't going to help you. You're going to be able to, you don't have to do this on your own.
Yeah.
You can pray over it and such like that, but you're going to have to do the work yourself.
Yeah.
You get that?
Yeah.
Okay. You also aren't allowed to use foul language in court.
Yeah, I know.
You can't say piece of shit in court. You realize that?
Yeah.
If you do that anymore, you could be held in contempt. You understand that?
Yeah.
If you obstruct the proceedings, you can be held in contempt. You ever heard of contempt before? Direct contempt?
Yeah.
Okay, well, if you act like that, I'll have to give you a contempt warning. We'll have to have a hearing on contempt and such things like that.
Judge, I don't know much, but I do know this guy knows contempt intimately.
You understand?
Trying to be respectful. That's why I called you Your Honor and stuff like that.
That's why I called you sir and things like
I
that.
didn't mean I wasn't even calling you. I wasn't even calling you that directly. I was just saying. I was just made a statement. That's it.
I understand, Mr. Conger. I just need to make sure you realize what you're working with
It
here.
wasn't at you directly.
We have certain levels of decorum and a lot of different processes and methods that we go through to get you through trial. Do you understand that?
Yeah.
Okay. All right. And one of them is that we're respectful to each other. We have civility with each other. You understand that?
Yeah.
Okay. Good.
I just already dealt with a lot in my life. That's all I'm saying. I've already dealt with a lot of stuff in my life. Like, I feel like enough is enough, but whatever happens, happens, I guess. I ain't worried about it.
Okay, Mr. Conger, that's fine, but I still need to get through this advisement. Okay, so we have a lot more work to do this morning. I just need you to stick with me.
Right.
Okay. All right. So, like I mentioned, the attorneys have the ability to understand about the aggravation and mitigation of your sentence. Do you understand that?
Yes, sir.
Okay. And they've also developed certain skills that would help you in presenting your defenses and to help a jury look more favorably on you, correct?
Yeah.
And one of those things is they can investigate your case, right?
I really don't care. We could skip over this. No offense. We could skip over this. I'm going with
I understand, Mr. Conger, you might like to skip over it, but I cannot skip over it.
I ain't trying to waste no time with that. I'm put in a situation where I can't trust them, and I'm good. I'm going with myself. So you,
Mr. Conger, you're not the one who ultimately makes that decision. I'm the one who makes that decision, and I can't do it without going through this advisement with you.
All right, you go ahead, read it, but I'm not going with that.
I'm not going to read it. I'm going to be interactive with you the entire way. I'm going to say words to you, and you're going to either acknowledge it or you're going to say you don't understand.
Well,
I'm going to have a conversation about
I'll
it.
listen to it, but I already know what the answer is. I'm going to decline it.
You're going to decline what?
Read it anyway.
You're going to decline what, sir?
Everything you're about to tell me.
Okay. Well, do you know that a lawyer can investigate your case?
Yes.
Do you know that they can talk to the witnesses against you?
Yeah.
They can do depositions.
Yeah.
They can find favorable witnesses that could help you.
Yeah.
You understand that?
Yeah.
Okay. They can help you understand the charges. Like I just had to go through exhaustively explaining the charges to you. They could do that. You understand that?
Yes, sir. Yeah.
Okay. Okay. They can also gather documents and find all kinds of evidence out there to present to a jury. Do you understand that?
Yes, sir.
Okay. They can prepare and file motions for the court. You understand that?
Yes, sir.
All right. Motions for discovery, motions like you filed for a speedy trial, and motions to keep unfavorable information out of the trial. You understand that?
Yes, sir.
Okay. They can examine witnesses. Have you ever examined a witness before?
Nope, but I plan on it. Yep.
If you look at this courtroom from your vantage point, can you tell me where the witness box is?
I know who the witnesses are.
You know where the witnesses are going to sit in your trial?
I don't know. Or I don't know who the witnesses are gonna be, but I want to cross-examine. I want to cross-examine them. I want to talk
You
to them.
earlier say that, Mr. Conger.
I want
Look to my left.
what?
Look to my left. Right there. See that empty seat right there? Right here?
Yeah.
That's where the witnesses sit.
Oh, yeah.
You get that?
Mm-hmm.
Look all the way over to your left, behind the officer here. See that? That's a jury box.
Mm-hmm.
That's where jurors are going to sit.
Yeah.
Probably 13 of them
Well, okay.
back
Good.
there. You're going to have to help
Thumbs
pick
up.
that jury. You're going to have to help pick that jury.
Yeah.
You're going to have to ask them questions in jury selection. Have you ever heard of that before?
Yeah, yeah.
You know what you would ask them during jury selection?
Yeah.
Well, you do already? What would be your first question in jury selection?
I'm not gonna tell you that.
You don't want to be on the spot?
Nope.
You're going to be on the spot a lot if you're trying your case yourself.
Nope.
That's a
You get that?
secret, Judge.
Not in trial yet. I ain't
Okay,
doing none
you
of
better get yourself ready then.
that. Not doing none of that.
All right. Here's another thing that a lawyer can do for you. They can present favorable sentencing information and attack unfavorable sentencing information. We talked about that already, didn't we?
Mm-hmm.
Okay. And they can recognize objectionable and unfavorable evidence and make objections to it during the trial.
Yeah.
Correct?
Mm-hmm.
You know how you would object at trial?
Yeah.
What would you do?
Object to trial.
Yeah. You ever watched a trial on TV?
It's just basically disagreeing with what they're basically disagreeing with what their point is they're bringing up. That's basically what it is.
I mean, basically, but there's going to be a witness on the witness stand. A guy like Hammer's going to be asking questions to the witness. You're going to want to object. You don't even know how you would do it?
Yeah, I know how to do it. Yeah.
What would you say?
I'm not going to tell you. We ain't at trial.
Objection.
Okay, sir. You better get ready. All right. The other thing that during the jury trial, the lawyer knows how to present opening statements. You know how to make an opening statement?
Yes.
You do?
Yeah.
Do you know how to make a closing argument?
Yes.
Do you know how to prepare jury instructions?
Yeah.
Do you know what a jury instruction is?
Jury instruction? No, I don't. I don't know what jury instruction is.
Okay.
I know the closing argument and the summary at the beginning or whatever. Yeah, I know that.
Okay. Do you know,
I'll figure it out though, whatever.
The
you know
rules
that
of
a lawyer
evidence.
has the training, knowledge, and skill to preserve the record of a case for purposes of an appeal?
Yeah.
Okay. Do you know lawyers could do that? Do you feel like you have the ability to do that?
Mm-hmm.
Okay. Is that a yes?
Yeah.
All right. An attorney can also evaluate the strengths and weaknesses of your case and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation of a favorable sentence in return for your guilty plea. You understand that a lawyer could do that?
Mm-hmm. Yeah.
Yes? Do you
Yeah.
think the state's going to make any offers to you if you go forward on your own without counsel?
I ain't worried about it.
Okay. Okay. You have to understand that if you decide not to have an attorney, you won't receive any special treatment for your defense. Do you understand that?
I usually go after my freedom every time and I just sign off to a plea bargain. But I'm a little tired of it. And this is what I'm going with.
I need you to acknowledge what I just said. You
Maybe you
understand that
should
you won't
stop
receive any
committing
special
crimes.
treatment.
I don't care. That's
You know that you're going to be treated just like a lawyer.
That's
the case.
fine. That's fine. That's
Okay.
fine.
You're going to have to follow all the same rules and procedures a lawyer would have to. You
Yes.
get that?
That's fine. That's fine.
Okay. State's going to have a lawyer. They got a guy like Hammer. He tries murder cases, rape cases, all kinds of battery cases, intimidation cases. He ain't no beginner. You get that?
Yeah.
Okay. Just want to make sure that you're clear on it.
Is this going to trial? And is this guy going to defend himself? I'm going to say no. I'm going to say sometime after this case, what the judge has been pounding into him for the last few minutes is going to change his mind. Oh, I hope it goes to trial, though.
If you decide to represent yourself and the result turns out poorly,
I mean,
you need to know that you won't be able to complain that you weren't effective in your own defense.
I don't want him to go to jail for 9.5 years just because we want to see this trial. You know what I mean? I'm torn right now.
You ever hear of the defense or the things people bring up called ineffective assistance of counsel? You ever hear of that before?
I don't care. Well,
Have you ever heard of it before, sir?
I forget. I didn't even listen to what you said. What did you say?
You ever heard of the thing called ineffective assistance of counsel?
Effective assistance. I kind of know what that means.
That's where when you have a lawyer and you think they did a bad job and you ended up going to prison for 80 years,
Oh yeah.
you tell the appellate court
Can't
you had a bad
complain
lawyer.
about the results. Is what you're saying?
That's what I'm saying. If you represent yourself, you can't complain that you were a terrible lawyer.
I guess it was my decision. Yeah.
You understand that?
Yeah.
Okay. You have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost always decide to be represented by another lawyer in a criminal case. You know that?
Yeah.
Like if I was going to be up, if somebody said I did something wrong and they filed charges against me, think I'd hire a lawyer?
Yeah.
Think I would?
Yeah.
You think I can afford a pretty good one?
Probably.
Yeah, I'd get a good one.
Yeah.
For sure. I wouldn't represent myself. Think I've got the experience to represent myself?
You probably do.
I do, but you think it'd be a wise move?
You gotta be a lawyer first, don't you?
For sure, for sure.
Or you might have been a lawyer first and then you moved up to a judge.
That's right. Do you think it'd be smart though for me to represent myself?
Yeah.
Okay. All right. Experienced lawyers almost always decide to be represented by another lawyer in a criminal case. There are some things you should consider before you appear at trial without an attorney, and I'm going to go through those now. I put you under oath a few minutes ago. So tell me, what skills or knowledge do you have that would be helpful if you represent yourself at trial?
What skills do I have? I'm good at winning arguments and stuff like that. And I really ain't worried about it. I ain't trying to go into that. We're not in trial yet. It really don't matter.
How many courtrooms have you been in?
How many what?
Courtrooms.
I've been in a lot of courtrooms.
How many?
Judge, trust me, he's been in a lot of freaking courtrooms.
A lot, sir.
I've been to some in Texas. I've been to the same courtrooms numerous times. So I've been to this courtroom plenty of times. Probably, I'm not sure which number this is or nothing, but
First time I've ever seen you in here.
yeah, you're Judge Fisk.
Yeah.
Yep, different judges. First time you was my judge. I forget if you was a judge from a long time ago or not.
You ever studied criminal law?
Criminal law? No, not really.
No.
Or maybe a little bit on the internet. Yeah. Maybe
Okay.
Yeah, I have. I guess you could say I have. And yeah, I guess you could say I have. Yeah.
So you've been in a bunch of different courtrooms, you say. You feel like you've got some pretty significant experience with the criminal justice system?
Yes, I do.
Okay. But how many jury trials have you been in?
I've never took myself to trial or none of that.
How many jury trials have you watched?
I've seen a lot of stuff on TV and I've looked a lot of stuff up on the internet. So I'm familiar with a lot of stuff.
Okay. What's your highest level of education, sir?
High school.
You graduated high school?
Yeah.
Okay. What was your focus in high school?
High school, I was thinking about going to college after that. That's basically it. But I don't know. My focus in high school, like, yeah, just basically going to college, and I was basically trying to get a good job to where I could do everything I wanted to do. You know?
I understand.
Guys, how would we answer that question? How would you answer that question? What if Judge Fish asked you, how many hearings have you ever seen in your life? How much court have you actually ever seen? Well, I was in a chat room, so just like this judge isn't on YouTube, a lot of my judges are not on YouTube. I get them other places, all right? And I was in a chat room with one of the judges a bit ago, and I got into an argument with one of the people in there. And he turns to me and he says, yeah, well, I've watched hundreds of cases. Hundreds? I said, "Oh, that's nice," and then I stopped chatting because, it wasn't worth it. But hundreds of cases. He's watched hundreds of cases. We've watched hundreds of cases in the last 3 days. We've been at this for years.
Dan, what occupations have you had since then? What was your first job out of high school?
Soft touch car wash.
You worked at a car wash?
Yeah.
Did you have to interact with people quite a bit at the car wash?
Yeah.
What'd you do after that?
What I do after that? I forget. I think it was landscaping. Yeah.
Okay.
It was landscaping, then the popcorn factory, and then Tanco terminals, asphalt, and then was working with hot asphalt. That's kind of dangerous. One guy got shot in the face with hot asphalt. I remember them saying. And,
Doesn't sound like a good time at all.
yeah, that was kind of dangerous. I accidentally overflowed one of the trucks on accident. That could have got on me.
Mr. Conger, have you ever done any work where you had to write or do a lot of reading?
Write or do a lot of reading?
You ever have to write reports or anything like that?
Oh yeah, like in the popcorn factory, yeah. I forget what kind of reports is, but you had to add all these numbers up, and I forget what it is. I could remember if I think about it, but I forget what it was where you had to add all these numbers up, and then you gotta.
I just feel like I can fix him,
I gotta
guys.
think about. Sometimes you gotta think about stuff for a while.
I just really feel like this guy is made for me. I feel a soulmate pull coming.
But I remember everything. I'm good at math. But
did you ever have to read a lot of regulations or read a lot of rules?
You have to check labels, and you have to make sure the expiration date's correct, and then you had to weigh all the bottles out, and then you had to add them up and find the average. That's what it was.
Okay.
And then divide them by whatever number. However, you find the average. You have to add them up and then divide them by however many bottles you weighed out.
Okay. Do you think you'd be good speaking in front of people?
Yeah. Yeah, I'm good at speaking in front of people.
During that jury selection process I told you about, there's going to be about 36 to 50 people in here.
Yeah.
All lined up in these seats behind you over here.
Yeah.
You realize that?
Yeah, I just feel like some people made me feel uncomfortable a little bit in my life. So like, I ain't always been good at speaking in front of people, but
you're gonna be able to do it for this because you're gonna have to.
Yeah, I'm good.
And then there's gonna be 13, I think, in the box. You're gonna have to present evidence in front of them, ask questions of the witness in front of them.
Yeah.
You're gonna feel comfortable doing that?
Yeah.
You have to make arguments. It's not like arguing like you're fighting in your kitchen about what's for dinner or such like that.
I understand.
It's a statement you're going to make to the jury about whether they should rule in your favor.
I'm not going to be overreacting or none of that. However things play out, it's going to play out. Then
okay.
I'm not worried about it.
Okay. Has there already been any promise or suggestion from anyone that you would receive special treatment or a milder sentence if you don't have a lawyer?
Wait, can you repeat that?
Have there been any promises or suggestions from anyone that you will receive special treatment or a milder sentence if you do not have an attorney?
No, I ain't talked to nobody like that, or nobody ever spoke to me about nothing like that. No.
Okay. Have there been any threats to you that you or another person would be harmed or disadvantaged in any way if you don't have a lawyer?
No, there ain't been no threats.
Okay. Do you have any questions at all about what it would take to represent yourself or about going forward in your case as your own lawyer?
No, I'm confident. Things work out no matter what, good or bad. It'll be all right.
So you still wish to proceed on your own and without counsel?
Yeah.
Okay. I will allow you to proceed on your own and without counsel. I have an offhand concern that I would suggest to you, Mr. Conger. You've definitely toned it down significantly since we've been working together over the last 40 minutes. You're going to have to maintain this kind of demeanor and attitude just like you are now, where you're professional.
Yeah. Right. I understand that. I usually don't act out of character like that. But I kind of got mad to the point where I didn't care no more, and that's why I did that. But I didn't act like that for
Look, he toned it down. Nobody's leg got broke in this courtroom. Nobody. Everybody's walking around fine.
years and years, and I kept it respectful for years and years. I just had enough, and that's why I did that.
I understand. Okay. So, yeah, we're in a little bit of a trick here with the motion for fast and speedy, because he made that all the way back on January 7th, State.
Yeah.
Hmm? I don't think April's going to do it. Huh. You see what's on March 17th? Yeah, I'll happily get rid of that.
Green beer
So the
is
17th
on
is the day.
March 17th.
Right.
Green beer.
Mr. Hammer, I just went through these charges as we're sitting here. Looks like you could do each one of these in a day. Is that right?
Yes,
Okay.
should be about a day, Your Honor.
Which one do you want to do first?
They have 5.
Okay.
I'm just wondering though, are you a new judge or have you stuck around for a while?
I mean, I'm newer. I'm not the newest judge.
Or
I've been at it
was
since
you
January.
around back in the day or no?
I've been at it since January of 2021. I've never met you before, Mr. Conger.
Yeah.
If you've got experience in this
Yeah, I
courts.
thought you was new, yeah.
Yeah. I think
Or you wasn't back in the. I was just wondering if you was back in the Judge Gent days or not. That's all I was wondering.
no, I practiced law back then, Mr. Conger. I never really quite got it right.
Yeah, I wasn't even asking about that. I was just wondering if you're in this courtroom for the Gent day.
I understand. So you're saying 70 ends on the 18th? Okay. So Tuesday, March 17th, we'll try the F5. And Wednesday, March 18th, we'll try the level 6.
I can get burnt sitting inside, Linus.
1 day each.
I can get sunburn
We'll
easy.
set them both up for pre-trial. Oh, really? February 23rd?
Yes.
That's fine. And we'll make February 23rd the cutoff for motions and things of that nature. 404B. And then I'll need instructions and things from the state by the 12th. Any instructions you want to put together, sir, you should get to me by the 12th. Any pretrial motions have to be filed by the 23rd. So motions to suppress, things of that nature.
So what's starting on the 12th? I wasn't paying. I was dozing off. My
By
bad.
March the 12th, the state has to have what are called instructions, proposed instructions.
Yeah. March 12th.
Yeah. You can file them if you want to file instructions as well.
Yeah.
Okay. And then any motions you have, including motions to suppress, are due by the pretrial date, which is February 23rd.
February 23rd.
Yes. And state's 404B disclosures are due by February 23rd as well.
Oh, when's the real trial gonna start?
On March the 17th,
March 17th.
St. Patty's Day.
February.
We'll do the level 5 that day. And they'll do the level 6 the next day.
All right.
Okay.
Yeah.
Do you have any questions about anything?
No. It should really be a level 6, but whatever.
On the 20th? Yeah. Mr. Hammer, are you available on Friday the 20th?
Of February?
Yeah.
Yeah, I should, because the only thing we had was Luna that week.
You want to, let's do this pretrial on the 20th rather than the 23rd at 9 a.m. Because Pribble's out and there's only one case on my 9. And we'll transport the defendant over for that one as well. Yeah. How you been? I just recognized you. Yeah. Huh? No. Is there one? Oh. Courtney White's not in custody, is she? I don't think so. Yeah. Okay, Mr. Conger, there's an additional wrinkle here in your case that I just was reminded from my trusted staff member here to my right. Back on December 31st, the state of Indiana filed the habitual offender enhancement notice. In it, they say that they intend to seek an enhanced sentence in this case pursuant to Indiana Code 35528D1. Did you get a copy of this?
Yeah, I did receive a copy of that. Yeah, I did.
You've seen it?
Yeah.
Okay. It says that back on January 3rd, 2023, you were convicted of a felony in Porter Superior Court, DO 52106 F6 5703, resisting law enforcement, a level 6 felony, and that crime was committed on June 10th, 2021, and that you were sentenced to 304 days in the Porter County Jail with none suspended.
Yeah.
They also say that on June 30th, 2020, you were convicted of a felony in Porter Superior Court under cause number DO 31902 F6 1494, possession of methamphetamine, a level 6 felony, committed on February 13th, 2019. And that based upon that conviction, you were sentenced to 230 days in the Porter County Jail with none suspended. They also say that on July 10th, 2013, you were convicted of a felony in Porter Superior Court. In this court, under 64D011304 FC 3052, strangulation, a Class D felony, committed on or about April 1st, 2013, and that based on that conviction, you were sentenced to 1 year in the Porter County Jail with all but time served suspended. They also say that on January 10th, 2013, you were convicted of a felony in 64D04 1208 FD 8655, possession of a controlled substance, a Class D felony, committed on or about August 23rd, 2012. And based upon that conviction, were sentenced to 2 years in the Indiana Department of Corrections, all suspended except 60 days to be served in the Porter County Jail and community service. Do you understand what they allege are your previous or prior convictions?
Yeah. Well, I understand everything, but
You understand what they allege are your prior convictions, sir? That's all I'm
yeah,
asking.
I understand. Yeah.
Okay. So I just need to advise you that if you're convicted of a felony in a jury trial, that for the level 6 felony, if you're found to be a habitual offender, there's an additional fixed term between 2 and 6 years for the level 5 or level 6 felony. So for either one of these cases you have pending, right? I told you about 3 charges you have pending against you. One of them is a level 6, one of them is a 5. There is the possibility you could be sentenced to an additional 2 to 6 years in prison based on the habitual offender enhancement.
Habitual don't make sense to me. It really don't. But I understand, and we'll just go with that. I guess we ain't at trial yet. I'm not gonna get into that.
Just be advised, it's not a separate crime. It does not result in a consecutive sentence. It is a non-suspendable sentence in the amount of additional term between 2 to 6 years.
Yeah, I'm just gonna let you know if you're gonna say 2. if you're gonna say two resistings is a habitual, that don't make no sense.
I'm just telling you what the state alleges pursuant to Indiana Code 355028D1. You can look up the statute yourself, but I think your exposure here is increased as a result.
Habitual should mean you did it like 5 times or something like that. Two resisting shouldn't be habitual, and that don't make no sense.
Well, once you're
But
back on your feet, Mr. Conger, I suggest you get involved with the legislature, something of that nature, so you can have some influence over the laws. Okay?
Yeah.
Okay, because what you think sitting there doesn't really amount to a hill of beans, right?
Yeah.
Okay. So I'm going to have you back on the 20th. That'll be our next hearing date. We've
Okay,
got a
yeah.
bunch of deadlines that same day. And then you're set for jury trial on March 17th and 18th. If you fail to appear at your own jury trial, we're going to hold it even if you're not here, and you can be convicted even if you're not here. You understand that?
Yeah.
Okay. You have any questions about anything?
Well, convicted? Oh, no, I don't.
Okay. Anything further state?
Your Honor, I just want clarification. So you said a lot of things were due on the 20th of February. You said the motions and instructions were due on the 12th, correct?
That's right.
Okay, I want to make sure that, so what's due on the 20th?
Motions are due on the 20th.
Okay, motions are due on the 20th, okay.
Yeah.
Okay.
In particular, motions to dismiss or motions to suppress, things of that nature. I want to make sure there's a deadline in there that gives me time to rule whatever
Okay.
impacts that might have on the trial.
Okay, then I misunderstood what was,
Instructions are due
okay.
right there at the end.
A-
And motions
it's-
in limine.
Okay, so motions in limine.
I'm never
pretty
mad
much
at
the
Bobby.
state Deadlines, the motions in limine deadline and the instructions deadline is the 12th.
Yep.
Okay.
And your 404 stuff's due on the 20th as well.
Okay, gotcha.
Yeah. Because that also could take some time.
Yes.
Yeah. What are you going to wear to the trial?
I'm not going home. It don't look like, so probably this.
Is there anybody who can bring you clothes?
I don't think so. No, I can't get a hold of nobody.
Well, I need you to try.
I came jail in an outfit. If I
What kind? What was it?
It had a corn, it had a corn cob on it, and it was
I don't
looked
like these.
I don't know, I don't know. I just came jail outfit. That's all I know.
Okay. Yeah, I would ask you to work on that because
Yeah.
for you to stand up in front of a jury, you won't have handcuffs on and stuff, but if that's what you're wearing,
Mhm.
they're going to know you're in custody, right?
Yeah.
Which isn't perfect from my perspective.
Mhm.
But it's also could have some influence, could have some bearing on how they feel about you,
Yeah.
right? So what's
Right,
important
right.
is that we mitigate that as much as possible.
I can't get a hold of nobody though, and I'm not trying to with the restraining order.
Oh, I recognize that you've got some
not trying-
constraints.
I'm not trying to get a hold of nobody on restraining order. I didn't violate.
Do not call your mother, sir. Do not.
Place, so.
I realize there are some constraints, Mr. Conger, but what I'd love to see is for you to be more presentable in front of a jury.
Right.
So work on that for me, okay?
My little brother won't answer his phone. Yeah, my little brother won't answer his phone.
That's something else a lawyer could have helped you with, but that ship has sailed now, I guess.
Yeah.
Okay. Yeah. Anything else,
No, Your Honor.
sir?
No.
Good luck. We're adjourned.
Well, guys, March 17th, one trial. March 18th, another trial. Listen, honest to God, I don't care if the trial is each trial is a day long. We're showing those trials. We're showing these trials. We just are, because I don't think it's going to go to trial. I think chances of this going to trial are slim and none. I think he's going to get a lawyer. I think that he's going to take a plea deal. But I'm showing these trials if they happen. I don't know if I'm going to show them one great big long session or cut it up into a couple days, split it up. I don't know. But I'm going to work on Tuesday. My weeks off are almost over. They're winding down. That went really quick. I go to work on Tuesday, but it's just I'm not back to work yet. It's just, you know, a special thing on Tuesday, but it's getting close. But I really appreciate it. Love, I hope you can get rid of some dogs. I hope you can find some dogs some nice homes. And I'll see you guys tomorrow night. All right? Sleep in tomorrow morning and behave. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so